The matter of Martin Brickner versus Jennifer Brickner.
For the record, this matter is before the court for continued pretrial conference. Substance of the parties having engaged in mediation yesterday with Mr. Walker from the front of the court. Present this morning is Attorney Timothy Churchill representing the plaintiff, Martin Brickner. Mr. Brickner appears to be present with Mr. Churchill. In addition, Attorney Anthony Bresco is present representing the defendant, Jennifer Brickner. Ms. Brickner, are you present on audio?
Yes, I am.
Good morning. Good morning, Mr. Bresco and Mr. Churchill.
Good morning, Your Honor.
The parties made progress but did not reach a full agreement yesterday. Is that correct?
That is correct. Yes, Judge.
Is there a continued mediation session scheduled?
No, Your Honor. Yeah, we were going, Josh was going to give us some proposed dates this morning.
Your Honor, there's one of the concerns that I have is that we were making so little progress yesterday that I didn't want to schedule another 3-hour session and make it just a waste of time. We still need to get, there's things that needs to happen. We need to get into the house so we can take inventory of the marital personal property, and we're being denied access. So we don't know how to handle that problem without me filing a motion. So we've got things we need to do before a mediation would be productive.
Okay, well, the court likes to at least take the proof today. This being a deal case.
Yep.
Do you need Mr. Walker? I don't know if he's available this morning. I mean, it should have been discussed yesterday in terms of a date so that people could inventory the contents of the marital home. Let's address that this morning.
Okay. Josh said that he would be up there this morning. He said he'd give us a continued date today. I know we went till about 4:45 yesterday, and I think he was late getting out of there. And as far as the home, we were in the impression she's already got the personal property out of the home she wants. She has exclusive use. We're not denying they can't go in there, but give me a date and time and we'll accommodate it.
This weekend.
I won't be here this weekend if there's any issue.
I don't expect you to be there, Mr. Churchill.
Well, if there's a problem, and there have been problems there.
Well, can they agree upon a third party that'll be present? Is there concern about physical altercation? No one should take anything without the consent of the other.
This is an inventory, Judge.
Who's going through there should make a list. It's not yet in the court file, but didn't the parties enter into consent order that the marital home in Lambertville be awarded to the plaintiff?
Yes, Judge, and this is just regarding personal property that we want to inventory.
Lambertville home, correct?
Yes, Your Honor.
Okay, so what about this weekend? Can the parties agree upon the 10 o'clock this Saturday? Can they agree upon a third party being present that they both are comfortable with and can trust?
Yeah, Your Honor, one other thing we want to ask too, a little over a month and a half ago, she came in, there were 2 trucks there, they loaded up a whole bunch of personal property. He says she has a lot of the marital personal property at her home now, and he would like to see what is there.
That's fine.
She took out of there.
That's fine.
Okay, let's have a time. Mr. Walker is handling the 8:30 motion this morning. Ms. Brower, however, has appeared. Do you want to talk with Ms. Brower briefly? To certify dates and times that the parties will meet at both homes. The plaintiff is residing in the Lambertville home. Defendant.
Jenny, do you have time to do this morning, or would you prefer to just put the proofs on and I can call Tim and coordinate this?
Yeah, I'm at work, so I'm not able to do that this morning.
Okay, Judge, if we could put the proofs on. I didn't schedule this. I screwed up my book for Miss Brickner, and she's at work this morning, but I can get the dates with Tim, and even I can meet with Aaron and Tim and the plaintiff and coordinate it afterwards. I just need to let my client go after proofs.
Okay, that's fine. And again, obviously no one should remove anything, just simply make a list or take a video of things so that they can exchange lists. But the court obviously, so we'll take the proofs to court. I do have mediation list, and then you want a trial date, Mr. Brasco, if we say mediation has been
yeah, something far enough off to give us a chance to resolve it. This should resolve. There's very, very little property here. This is just a situation where we've reached an agreement as to the biggest asset, and now we're being stonewalled on all the little assets, and so we have no other choice but to move things forward.
So we're maybe just another, take the proofs that said another pre-trial in a couple weeks, and if necessary, the court at that time could schedule an evidentiary hearing or another mediation, or for the two of you can perhaps work with Mr. Walker for another mediation date. All right, let's take one step at a time. The court will take the briefs. Mr. and Mrs. Brickner, the court's going to take some brief testimony because the court's under a time frame to adjudicate this matter. So we're just going to establish jurisdiction. There's been a breakdown. There are no minor children. And Ms. Brickner is not now pregnant. The court will reserve all issues. So if you could both please raise your right hand to be sworn, please.
Raise your right
Yes,
hand.
Ms. Brickner, do you both solemnly swear affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Mr. Churchill, if you get to commence with Mr. Brickner and taking the proofs, please.
Okay. Marty, is it true that you were married to Jennifer Dawn, now known as Brickner, in Jamaica on May 25th, 1996?
It is.
Is it also true you filed a complaint for divorce?
It is.
Immediately preceding and filing the complaint for divorce, were you a resident of the state of Michigan for 180 days as well as a resident of the county of Monroe for 10 days?
Yes, sir.
Is it also true there's been a breakdown in the marital relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood the marriage can be preserved?
That is correct.
Okay, is your wife pregnant at this time?
Not that I'm aware of.
Okay, are there any minor children at this time?
They're not.
Is it true there were 3 children born in the relationship and they have all emancipated?
That is true.
Okay. And you are working on the property settlement issues at this time and have agreed to some partial property settlement issues?
That is correct.
Okay, thank you.
Thank you, Mr. Churchill. Mr. Bresco, do you have any questions of Mr. Brickner?
No, not at this time, Judge.
Questions for Ms. Brickner, please.
Jenny, did you hear all the questions asked of your husband?
Yes, I did.
Did he answer them all accurately?
I believe so.
And are you presently pregnant?
No.
Okay, nothing further, Judge.
Thank you, Mr. Bresco. Based upon the testimony that's been presented this morning, as well as complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. At this point in time, however, the court will hold in abeyance and reserve all outstanding issues. So with that, Mr. Churchill, Mr. Bresco, you will confer regarding each party being able to examine the personal property in the possession of the other party. The court suggests the next pretrial conference we can do by teleconference. The court can have a frank conversation with counsel, Mr. Bresco, Mr. Churchill, whatever your pleasure. You want a pretrial maybe 2 or 3 weeks. At that time, determine where we go forward.
All right. Right now, Your Honor, we are waiting on the appraisal to get done. It is scheduled to be done on November 7th. I'd ask if we could do it maybe 5 to 10 days after that. I think once we get the appraisal, we can start making some headway on these issues.
Okay.
Or the remaining issues.
What was the date that you expect the appraisal, Mr. Churchill? Once again, November?
The appraiser is coming out November 7th.
So can you get it done within a couple weeks thereafter?
Yeah.
Okay. So maybe pre-trial late November, early December, Mr. Churchill, Mr. Bresco.
Your Honor, my only conflict is I'll be out of the country from the 20th to the 24th. So that Wednesday, the 20th, we're going to be leaving for a family vacation.
Until December 24th?
No, that's November, Your Honor.
I see. All right.
It's just 4 nights, Your Honor.
Okay.
Yeah, I would think if we look around the 15th or 18th, 20th, somewhere around there, that would work. If it works for Tony.
Typically, the court conducts pretrials on Fridays unless there's mediation, and I try to tag along with mediation. Unfortunately, I was not available yesterday late afternoon. So let's look at a Thursday or Friday. What about December 6th? Either that or I don't know if the courthouse is open on November 29th, day after Thanksgiving. Okay, no, they're closed. 22nd of November or the December 6th. Any preference?
I'm going to be out of the country on the 22nd.
I'm sorry, Mr. Bresco. You're right. Yeah.
I'm available the 15th and the 6th, Your Honor.
Mr. Churchill, how about December 6th? Make sure we have that appraisal. Friday, December 6th, it'll be a teleconference.
I can't do the 15th. I've got a trial that day.
December 6th. Friday, December 6th.
Yep, that should
8:30?
work.
Will 8:30 work with both of you?
Yes, Judge.
Your Honor, I've got the continued Obreu Perez mediation that morning. I've also
What
got a
time?
9 o'clock and Judge Nichols and a 10:30 with you. Could we do it later that morning?
Yes, Judge. Tim, I'm available that whole morning.
Okay, what time on later in the morning on the 6th?
My last one's 10:30 with you, Judge. So 11:30?
What about 1:15? Well, 1:15.
I'm available.
That works.
All right, court without notice on continued pretrial conference, December 6th, 2024, 1:15 via teleconference. Court will initiate the conference. If you're not at your office, then please provide a cell number.
Okay.
Got it, Your Honor.
All right, anything further this morning?
I'm willing to pop in with Aaron and Tim to try to hammer out the details for this weekend, and I'll just let my client go.
Okay,
Okay, one other issue I wanted to ask, we had talked yesterday, the parties have 5 vehicles. Everybody's short on cash here. We talked about selling one of the vehicles, and I'm wondering if we could do that at this
all right,
time.
why don't you talk with Ms. Brower? I think she's still
Okay.
available.
All right,
Okay.
good enough.
Aaron, are you still gonna take? the
Jenny,
9
give my
o'clock?
office a call before you head back into class.
Say that again, Tony. I didn't hear you.
I said, just give me a call at the office real quick before you head back into class. It'll only take 1 minute.
All right.
All right, seems like Ms. Brower's got here at 9 o'clock matter this morning, Mr. Bresco, so it's not working. Obviously, we got started late this morning, so you can talk with Mr. Churchill. If you can't resolve it,
I'll call him right now, Judge. We'll talk.
okay,
Enough.
all right.
Okay, thank you,
All right,
Judge.
that concludes my call. Zoom out. This matters
Thanks,
before the
Judge.
court on the plaintiff's motion to revoke parentage. This hearing is being conducted via Zoom. Sir, are you Dominic McNamara? Need to unmute yourself? You both need to unmute yourself. Are you Dominic McNamara?
Yes, sir.
Thank you. Are you Jenna Roberts?
Yes, sir.
All right, good morning. Both parties are present. Good morning, Ms. Brower.
Good morning, Your Honor.
The parties have conferred with Ms. Brower from the front of the court, who's provided the court with the following recommendation relative to this motion. Court has received the following recommendation, and if adopted, will become an order of the court. The recommendation is that both parties and the child shall appear at the Monroe County Courthouse on November 7th at 9:30 a.m. for DNA testing through DDC. Plaintiff, Mr. McNamara, will pay for the cost of that testing. Can't tell exactly the cost, but it's approximately $500, Mr. McNamara. And Ms. Brower, does he have to contact the agency ahead of time to make a credit card payment?
Yes, Your Honor. I provided him the phone number for DDC to contact them prior to next Thursday and set up payment.
All right, Mr. McNamara, you have that phone number?
Yes, sir.
So you'll call them today and make a payment over the phone, is that correct?
Yes.
Because if you don't, then they're not going to do the testing on November 7th. You need to move on this. We can't be adjourning this matter and adjourning it. So the recommendation is that you both shall appear on November 7th. Do they need an appointment? Do they need to schedule that appointment, Mrs. Brower? Are you scheduling that for them?
We're scheduling it for them. Friend of the court has their DNA testing
Okay.
every other month, the first Thursday of the month, and it is their next date is November 7th.
Oh, wonderful. So there you have a time slot available at 9:30. Is that correct?
Yes, Your Honor.
And is that conducted when the Board of Commissioners Committee room?
Yes, Your Honor.
All right, so when you come into the courthouse door that morning, it's right on the ground floor, right off the near the elevators. There's a conference room when you walk through the security. So you both need to appear at 9:30, and you're both available that morning, correct?
Yes, sir.
Yes, sir.
Okay. And then further, the two of you shall appear before the court to review those DNA results on the Tuesday, December 10th at 8:30 via Zoom. So it'll probably take a couple weeks. It's simply a saliva test, non-invasive. So you both need to bring the minor child, Mr. Roberts. I understand that. And then we'll have you both be mailed the results. I presume when you do the testing, they'll get both your mailing address at that time. You both get the test results when you appear on December 10th at 8:30. You can then make some decisions. And if Mr. McNamara is not the biological father, Ms. Roberts, you're going to have to be prepared to inform the court who the biological father is. Do either of you have any questions?
No, sir.
No, sir.
All right, the court will adopt the recommendation this morning. Thank you, Ms. Brower. You'll both be mailed a copy of this. So mark on your calendar, November 7th at 9:30. You're a little bit early, and then appear before the court December 10th at 8:30. Right, if there's nothing further, you can both zoom out. Have a good rest of the day. Thank you, Ms. Brower, again.
Thank you, Your Honor.
Yeah.
To revoke parentage. This hearing is being conducted via Zoom. Are you Dominic McNamara?
Yes.
It appears that Ms. Roberts is not present. She was present on October 29th, which time she was advised that this matter would be reviewed by this court today, December 10th at 8:30 a.m. It's now 9 a.m. Ms. Roberts has not appeared. She's not contacted the court. Obviously, she did appear with the minor child at the time of the DNA testing. Mr. McNamara, you went to the courthouse on November 7th for the testing. Is that correct?
Yes, sir.
And Ms. Roberts was there with the minor child, Blake?
Yes, sir.
Okay, so you saw her there. Was there any discussion between you and her about this court date?
No, we did not talk at all, but I did see her and her family though.
Okay. Did you make any effort to contact her this morning to remind her of this court appearance?
Yeah, I texted her through text message, but she has me blocked, but I had sent a text to her mom, the same thing with the user ID, and that went through, but I don't think I've heard anything back yet.
Your Honor, I also did reach out to Ms. Roberts on the phone number listed on the summons. It went to voicemail. I did leave a voicemail that she did miss her hearing at 8:30 this morning and to appear.
Thank you, Ms. Brower. For the record, that's Ms. Brower for the front of the court. So reasonable efforts have been made to remind Ms. Roberts of this court date. In any event, the court is in receipt of a DNA test report from DDC dated November 14th, 2024, indicating that the alleged father, Dominic McNamara, as well as minor child Blake, submitted DNA samples, and the results of the test is there's 0% probability of paternity. Mr. McNamara, why did you sign an acknowledgement of paternity on July 29th?
Pardon me?
Why did you sign an acknowledgement of paternity on July 29th, 2024, after this child was born?
Well, I was kind of led to believe that she was mine, and we were kind of in a relationship for little under a year beforehand, and so I kind of just believed everything going up until we did a net home test and then went forward.
Very well. Ms. Brown, do you know, as Ms. Roberts, is she receiving public assistance for this child?
I do not know that, Your Honor.
Okay. Hey, Beth, even though Ms. Roberts did appear back on October 29th, 2024, she has not filed an answer to the complaint seeking to revoke paternity. She's not appeared today. Accordingly, Mr. McNamara, the court will grant the relief requesting. The court will enter an order revoking paternity. It's unfortunate we have Ms. Roberts here, so we can determine who the biological father is. But you represent yourself. You need to submit to the court an order.
Pardon me? What was the last part?
You are representing yourself, so you need to get an order, prepare an order to the court to sign revoking paternity. You went online, got these forms, a complaint, revoke paternity and so forth. Wherever you got those forms, did you get those online?
To revoke the paternity.
Mr. McNamara, wherever you got those forms, you got to go back and find an order revoking paternity. You need to submit that to the court.
Okay, yeah. Yeah, I'll have to send it to the court, you said?
Well, deliver it.
Okay.
I mean, the court speaks through its written order, so you need to submit it this time. The court will grant your the relief you are requesting. The court will enter an order determining that you are not the biological father of this child, and the court will revoke paternity. But you need to prepare that order and submit it to the court for signature. This will not be concluded until you do that. Do you understand that?
Yep.
You need to do that as soon as possible, and hopefully within the week.
Okay. All right.
Probably should have gotten that together once you got the DNA test results.
Yeah, it's probably sitting in my room. I was just unsure of that.
Okay, and you still live in Gibraltar, is that correct? Still at 29110 hidden?
Yep.
All right. Mrs. Barrow, I suppose you could always prepare in front of the court order, but I think we also need, Mr. McNamara needs to submit a SCAO order, revoke paternity. So once again, Mr. McNamara, the court will grant the relief you're requesting. Do you have any questions?
Like just the name of the two orders that I have to turn in.
Well, it's just one. It's an order revoking paternity.
Oh, I thought you just mentioned another one. I apologize.
I think Ms. Brower is simply prepared just a notation for the court that the court is granting your motion to revoke paternity, and that you'll submit an order revoke paternity. So we need that. It needs to be done in your part since you're representing yourself.
Okay. All right.
So court will look forward to receive that in the next, hopefully, certainly want to do it this month. Let's get it done. Close out this file.
Oh yeah, I want to get it done as soon as possible as well.
All right. All right. That will conclude this matter, Mr. McNamara. You can zoom out.
Oh, okay.
Do you still have a relationship with this Miss Roberts at all?
No, I have not talked to her since I have gotten like the first set of results back. We talked a tiny bit, but there was nothing good coming out of that. So,
okay. All right. That will conclude this hearing. You can zoom out. Good morning, Ms. Brower. For the record, this matter is before the court on the defendant's objection to a referee recommended order regarding child support. This hearing is being conducted via Zoom. President Attorney Maria Zagorski representing the plaintiff, Michaela Stango. Ms. Stango is present. In addition, Attorney Elizabeth Quinn is present representing defendant Colin Quinn, and Mr. Quinn is present. Good morning, everyone.
Good morning, Judge. Good morning.
And for the length with Mr. Walker from the front of the court this morning. Court is aware there are other outstanding issues. The court sees that there's a parenting time hearing before referee Hamrick on November 14th. Parties have agreed to engage in mediation to address and resolve all the outstanding issues. Is that correct? Child support, parenting time, and so forth. Is that correct, Ms. Gorski and Ms. Quinn?
Yes, Your Honor.
Okay. Right. Mr. Walker will assume he sent the court a recommendation. There it is. Mr. Walker's recommendation is that the parties shall follow the Monroe County Friendly Court holiday schedule. Any child support order ultimately entered shall be effective August 1st, 2024. The hearing before referee Hamrick scheduled for November 14th, 2024 at 11 a.m. shall be vacated. Fathers shall have parenting time every other Friday at 10 a.m. to Monday at 11 a.m. on a temporary basis pending mediation. Fathers shall provide all transportation, and fathers' parenting time shall commence on Friday, November 1st, 2024. The parties shall mediate with Ms. Brower from the front of the court on December 5, Thursday at 1:30 p.m. via Zoom, and then subsequently appear before this court for a continued pretrial if the parties are unable to reach an agreement. That is a recommendation. Ms. Quinn, is this recommendation good with your client this morning?
Yes, Your Honor. It's not perfect. It's not the ultimate outcome that he would like for this case, but he is satisfied with it on an interim basis. He would like for mother to be responsible for some transportation, but he understands Mr. Walker's recommendation and is fine to operate by those terms for the time being.
All right, thank you, Ms. Quinn, and the reality is it's not a perfect world we live in. Mr. Gorski, is this recommendation good with your client this morning?
It is, except for, Judge, we're asking that the front of the court holiday schedule be adopted effective November 1st. And the reason is that Mr. Quinn had Halloween last year with the minor child, so my client would like Halloween this year with the minor child. I think you understand the importance that Halloween has taken with respect to young children. And because she didn't have it last year, she'd like it this year. And just so that you're aware, I think Ms. Quinn is going to assert that my client has all the holidays. I would just put out there that the child was isolated last year for Christmas because she had RSV. Mr. Quinn had to work on July 4th, and she didn't know it was his birthday when he wanted the child on his birthday. So wait, all of that aside, we have no problem adopting the front of the court holiday schedule. We would just like it to be November 1st.
Very well, and of course, the front of the court holiday schedule does indicate that in even numbered years that fathers shall have Halloween from 4:30 until 8:30. Any objection, Ms. Quinn, to that party's understanding that dad will have Halloween this year from 4:30 to 8:30?
No,
Yes, Your
my
Honor.
client would have it, Judge. My client didn't
I'm
have
sorry.
it last year.
Okay, was that discussed with Mr. Walker this morning?
It was.
Okay, Mr. Walker, what's your recommendation in that regard? Did you, the recommendation is not clear in terms of whether or not it does say the party shall follow the front of the court holiday schedule.
Your Honor, my recommendation would be that because basically, to be honest with you, it's because the parties can't agree on the holiday and what should happen with it. I was going to adopt the front of the court holiday schedule immediately.
Okay, and if we adopt that immediately forthwith, then father would have Halloween, and you're opposed to that, correct, Ms. Gorski?
Yeah, just because he had it last year and I understand that going forward, we'll have the front of the court holiday schedule, but he had it last year and Halloween is a big deal.
If I may speak to that, Your Honor.
Hey, Ms. Quinn?
Thank you. If Ms. Zagorski and her client would be willing to offer my client every holiday other than Halloween for the next 2 years, I don't think that we would have any objection to what their ask is at this time. But I think that there's going to be some growing pains with the adoption of this holiday schedule. I don't see any reason as to why it shouldn't be implemented now. Halloween was the only holiday that my client has ever spent with a minor child, and he believes that he only spent it with her last year because it fell on a day that he ordinarily had time with her, and Ms. Stango had other plans. That's his understanding. He'd like Halloween. He'd like to operate by the holiday schedule unless or until we can come to another agreement. But I think that it's going to be difficult for mother who's exercised parenting time on all holidays other than Halloween last year to come to terms with this schedule. We would ask that it be implemented immediately.
And we're setting the tone going forward, Judge. This is exactly the problem that I'm having. We all understand that Halloween's important. We had it last year. My client has made concessions today. Quite frankly, right now, pending a hearing, we have reasonable and liberal parenting time. That is the current order. We're here on a de novo hearing. We're scheduled to address parenting time on November 14th. My client came to the table in good faith. She's been cooperative. She's been making concessions, and there are no concessions being made on the other side. We're just asking that, and we'll live with the front of the court holiday schedule, although arguably it's not wonderful for very small children, and you know why. We're just asking that it be adopted on Friday instead of on Thursday. Mr. Quinn plans to drive from Grass Lake, where he elected to move, to Monroe and pick this child up at 4:30 and drive this 2.5-year-old back to mom at 8:30 on Thursday night and drive back to Monroe on Friday morning at 11 and take her back to Grass Lake this Friday. So just to flex, I guess, he would have this child in the car for over 3 hours in a 12-hour period to get what he wants. That's what we're dealing with.
Right.
Just like to note that.
Ms. Quinn, was Mr. Quinn intending to drive all the way back to Grass Lake for these couple of hours? It's a lot
Well,
for
Your
the
Honor,
child. Don't we have local family in Monroe?
Yes, Mr. Quinn is my brother-in-law. I live in Monroe,
Okay.
approximately 5 minutes from Miss Stango. He could stay at my house on Thursday night if he would like to.
What can the part, what about the splitting the time? One parent is from 4:30 to 6 o'clock. No one has from 6 to 8.
That was not something that we discussed in detail with
Right, the court is
Mr. Walker.
proposing that. Why would that work with the child stays here in Monroe and that the parties divide up? Typically, we have a 2-year-old child, correct? Typically, a 2-year-old is not going to go walk a dozen homes. The 2-year-old is typically going to visit family members, grandparents, uncles, and aunts, correct? So
Yes,
why can't the parties share that?
It was my understanding that Miss Stango wanted to take the child to some place in Perrysburg, Ohio. It's what was conveyed in our session with Mr. Walker.
Yeah, Judge, we invited
Mr. Walker, can you talk
Quinn.
with the party? Miss Quinn, Miss Gorski, you want to talk to Mr. Walker again? Why can't the parties divide up? And no one is going to drive to Perrysburg, Grass Lake. Let's keep the child here in Monroe. I mean, aren't there other family members, relatives here in Monroe? That 2 years is going to basically see uncles and aunts and grandparents. That's it.
Sure.
Can they divide up Halloween? It's going to rain anyways, so the child's not going to be outside going door to door. And there's nowadays there's more trunk or treats than there are. Those seem more appropriate for young kids than actual Halloween day. It's going to be cold and rainy on Thursday, so this child's not going to be outdoors going door to door. Why can't the parties split up then this Thursday?
We would be fine with that, Judge. We invited Mr. Quinn to join us.
Mr. Quinn would not like to spend the Halloween holiday in Perrysburg, Ohio, when it's awarded to him in the.
No, the child's going to stay in Monroe. Why does the child have to be driven to Perrysburg, an hour away?
My
Ms.
whole
Gorski?
family lives in Ohio, Your Honor.
I'm going to talk to Mr. Walker briefly. Unless, do you want the court to just make a decision? Because what the court's going to do, we're going to split Halloween. That's what we're going to do for 2024. We're going to split Halloween. Who wants the first shift? Who wants the second shift?
I want the second.
Since Dad's the first shift, court would order that Dad have Halloween from 4:30 till 6 o'clock. Mom can have Halloween thereafter because the child's going to be at Mom's house that night, correct?
Yes.
All right. So, Mr. Walker, you had the recommendation that Dad will have the child on Halloween from 4:30 till 6 o'clock, and Mom will have from 6 o'clock the remainder of the evening. Anything further than this morning, Ms. Quinn or Ms. Gorski?
No, Your Honor.
Michaela, I'll give you a call.
So again, Dad's going to be, he's going to pick up the child at 6 o'clock and then bring the child back to Mom at, I'm sorry, he's going to pick up the child at 4:30 and return the child to Mom at 6 o'clock, correct?
Would it be 6:30, Your Honor, if it's a 4-hour time period?
Well, again, Mom's going to, Mom wants to go to Perrysburg, is that correct? I mean, it's sort of late for this child. I mean, I think an hour and a half for both parents are sufficient. I think Halloween, this time frame for the front of the court schedule is really too late for a 2-year-old. So again, Dad will have Halloween appointing time 4:30 to 6 o'clock. We'll add that to the recommendation, and hopefully the parties can work out the other issues when they mediate with Ms. Brower on December 5 at 1:30. Anything further than this morning, Ms. Quinn or Ms. Zagorski?
No, thank you, Judge.
And Mr. Quinn, you and Ms. Stango need to start communicating. Think about it. You know what's best for your respective schedules, and you're asking a stranger to make these decisions. And that's what, if you want this court to raise your child, that's what the court will do. But it's very unfortunate that the two of you cannot see eye to eye and communicate effectively regarding a child you brought into this world. So with that, we will see everyone after the mediation on December 5.
Thank you, Judge.
All right, you're welcome. For the record, this matter is before the court on account of parenting time complaints made by each party against the other parent. This hearing is being conducted via Zoom. Present is Clayton Schieb.
Good morning.
And the video this morning, good morning, is Ashley Dran-Harper present on audio?
Yes.
All right, good morning to both of you.
Good morning.
The two of you have conferred with Ms. Pratt from the front of the court, who has provided the court the following recommendation. Her recommendation is a plaintiff mother's complaints be dismissed as they state that she kept the child during father's court order parenting time. She's recommended that the plaintiff mother be held in contempt for violating the orders of this court, and that the plaintiff defendant father be entitled to 7 days makeup time, and that father shall have the next 7 overnights of mothers. That is the recommendation. And obviously, this would also resolve and address your complaints, Mr. Schieb. You've made various complaints, a number of them, that mom's not ensuring the child completes homework. Obviously, both of you should make sure the child completes homework. And also that mom allowed the minor child to watch the Beetlejuice film. The court does not find those to be significant violations of joint legal parenting time. But in any event, that is the recommendation this morning. Mr. Schieb, do you understand the recommendation?
I do, Your Honor.
I'm sorry?
I do, Your Honor, yes.
Okay. There, we couldn't hear it first. Do you have any objection to the court adopting the recommendation?
I do not.
All right, Ms. Dran-Harper, do you understand the recommendation?
Yes.
Do you acknowledge that you denied parenting time to Mr. Schieb during his parenting time?
Yes, but I had a good reason to do it.
Okay, and what was the reason?
Graceland's schooling. She had open house one of the weeks, and then the next time I kept her was because it was her first day of school and Clayton was not there to get her.
Okay, so why would that give you a basis to deny parenting time?
Because she needed a parent to take her to those two things. He wasn't there. He was gone.
Okay. So you kept Grayson overnight then?
Yes, so I could take her to her open house and then so I could take her to her first day of school.
Okay. Mr. Schieb, your response?
So I had asked Miss Harper to switch weekends because I was going on vacation and I just wanted to co-parent and see, if we could switch weekends. She told me no. I made arrangements to take Graceland on our vacation. When it was time to get Graceland, I had sent my girlfriend's mom to get her because we wanted to surprise Graceland. Miss Harper completely refused because I was not there to get her. And I do want to say on the record that the last time we had any sort of mediation or court hearing, it was about who could pick up Graceland, and it was ordered that a trusted adult known to Graceland could do the pickups. Ms. Harper refused to show up for that hearing to voice her opinion, so the order stood in its place. I sent my girlfriend's mom to get Graceland. Ms. Harper refused. The day of Labor Day, I did the same thing. I was at home unpacking. I had sent someone there to get Graceland from Miss Harper, and Miss Harper stated, I was not there. I'm not getting my child. I did talk to Graceland on the phone and asked her specifically if she sees who is picking her up. Graceland had acknowledged that she's seen my girlfriend's mom and my girlfriend's mom's vehicle, which, in speaking of, Miss Harper's complaints even state that my girlfriend's mother was there to pick up Graceland, so she too knew who was getting Graceland then. I was just refused my time. Graceland missed out on one heck of a vacation and missed out on a lot of cool experiences.
Okay, so you're claiming that you're requesting 7 days of makeup parenting time, is that correct?
Correct, Your Honor.
All right, your response to Mr. Ann Harper. Obviously, there's nothing wrong with this other person that's known to Graceland to pick her up.
Graceland didn't want to go with her. Graceland didn't want to be in the car with her smoking cigarettes.
Well, no one should be smoking cigarettes in the presence of the child in an enclosed area.
Nobody does that, Your Honor.
Okay.
Well, Mr. Durant, did you talk with your girlfriend's mother and make sure she doesn't smoke in an enclosed car with a child?
No, she never got out of the vehicle to talk to me. She parked way in front of me where I didn't even know what vehicle it was, so Clayton said what it was. And when she was sitting in there, she was puffing on cigarettes out of her window. Grayson said when she's in the vehicle in the back seat, even when the mom is smoking with the window down, it blows in her face.
She does not smoke in a vehicle with Graceland. Nobody smokes in a vehicle with Graceland.
Okay.
And if I may state too as well, during that phone conversation, Ms. Harper had plenty of chances, even to this day, to message me or contact me about things like this. And I've never heard anything about this whatsoever. And that was never one of her many excuses as to why I was denied parenting time. It was simply, I'm not there and she don't know who's getting Graceland. And that was the extent of the reasons why I was denied my parenting time per Ms. Harper. And if I also may state, this is now the second time Ms. Harper has been held in contempt. The first time she was held in contempt, you have reserved jail time.
All right. Did Grayson know who was picking her up that morning?
She did.
Graceland asked me to not tell him because she was afraid that she was going to get yelled at by Clayton for not going with his girlfriend's mom.
So Grayson called you, Mr. Ann Harper, to pick her up?
No, she was with me in the car. I was going to drop her off. Clayton was not there. The girlfriend's mom was there. Graceland did not want to go.
So if Graceland did not want to go when I was on the phone with you, why wouldn't you communicate that with me?
Because she didn't want me to tell you, because she didn't want you yelling at her.
That makes absolutely no sense. If there's
It makes perfect sense because you always yell at her.
I do not yell at my child. But if there's something that can
I'm not arguing with you.
Smoking in the car with a child, that should be something that's immediately talked about.
Well, Mr. Schieb, has Grayson ever told you that your girlfriend's mother smokes in the car?
No, she hasn't.
Why don't you ask her about that? Why don't you ask Grayson about that?
And I will. And I know
if that's occurring, you need to put a stop to that.
And I agree, Your Honor, but I am 100% certain that my girlfriend's mother does not smoke in the vehicle with Graceland. She knows right and wrong, and she knows what is healthy for her child and not. She is a great human being and a great babysitter.
Okay, but maybe she was sitting in the car with her window cracked, smoking a cigarette when she was waiting there for Grayson. Then the car stinks.
Right, and maybe that is the case. But again, Ms. Harper isn't communicating these things to me, regardless if Graceland's telling her and in fear of getting yelled at. How are we supposed to co-parent or communicate or figure out what's best for our child if one parent is withholding things from the other parent and not trying to find a solution?
Well, Ms. Ann Harper stated that Grayson was concerned that you would yell at her.
Right. Well, if we're just going off that basis, I can say the same thing about Ms. Harper, but I'm not going to because my child is 10. And at 10, sometimes kids lie, sometimes kids stretch the truth. It happens, and I totally understand. If she's afraid, Graceland knows she can talk to me. She talks to me about everything. She has talked to me about how she came home and her mom and her boyfriend's making out on the bed, how her mom just lays in bed all day. There's plenty of things my child talks to me about, Your Honor. And if there's any concern, my child knows she can come right to me because I will find the best solution for her. I take care of my child 280 days out of the year. Miss Harper gets her for 80. There's a reason why things have changed so much in the past 4 years, Your Honor. And that's because I am giving my child the best life she deserves.
Okay. How's she doing at school, most importantly?
She's doing great now that I get her during the school year. Her grades have completely turned around and she's doing very good. She's struggling in math, but once she gets the hang of it, she takes off like a rocket ship, and she does phenomenal.
Okay. Why wouldn't you take her to the open house, Mr. Schieb? Obviously, school's important. At her age, going to open house is important.
Correct. I had a planned vacation for us, And yeah, it may have
Don't plan a vacation. If the education of your daughter is important, why would you plan a vacation during the beginning of the school year?
The open house was a week before school started. That's just to get to know a teacher and bring in school supplies. While I understand that may be important, giving my child a vacation when I can afford to give her one, even if it overlaps with meeting a teacher, I'm going to give that to her. She can meet the teacher on the first day. She knows who her classmates are. She's in the same school she's always been in. Yeah, I like I said, I get open house may be important, but giving a kid an adventure or an experience of a lifetime, things like that kind of outweigh an open house, in my opinion. I'd much rather see her see a baby sea turtle like we did, or climb to the top of a mountain and learn about these things while we're doing it, than to sit at home and do nothing all weekend.
And Grayson was deprived of that vacation. Is that correct? Because mom denied parenting time?
Correct, Your Honor.
Right. Did you inform mom that you vacation scheduled with Grayson and where we were going? Give her some idea of what you were going to expose Grayson to?
No, I didn't, because
that might have helped. Then she would have understood.
Right, but I
shouldn't
have to explain what I'm doing with my child when it's my
I understand. It would just maybe have helped some communication, and she would have said, "Oh, that sounds wonderful. I'm going to make sure that happens." I mean, this is just observation.
Okay, and I appreciate that. And next time I plan a vacation, maybe I'll give Ms. Harper a little bit of back information on it so she can make a judgment for herself.
All right. In any event, hear from both of you. The court's going to adopt the recommendation of Mr. Pratt, Ms. Schieb-Harper. I'm sorry, you did not have the right to deny Dad's parenting time for the reasons that you stated. So the court will grant defendant Father Clayton Schieb 7 days of makeup parenting time, the next 7 overnights of mothers. So and moms are what, Fridays, Saturdays?
Correct. She'll have Graceland this Friday overnight, and this Saturday overnight is her weekend, is this weekend.
Well, the court doesn't want the child to be without contact with mother for such a long period of time. So the recommendation is the next 7 overnights of mothers. We don't want mom to be maybe alternate weekends.
Your Honor, she goes to her mom's house every other Wednesday for a few hours. So she will still see her mom. And and I will say this again, like I say it every time I'm in court. We use app close. Ms. Harper is more than welcome to reach out to try to spend time with Graceland or pick up Graceland whenever she chooses. I am not a monster. I am just the other parent to a child. And if Ms. Harper wants to spend time with Graceland, she absolutely can. She just needs to communicate with me. She wants to do these things and actually do it within a reasonable time. And we
can the two of you agree upon when the makeup parenting time will be, the 7 days?
What was that? I'm sorry.
The two of you agree upon when the 7 days of makeup parent time will be. Keep it in mind, Grayson's best interests.
Yeah, we already agreed to the next 7 overnights.
Okay, but that's basically on mom's weekends, correct?
Yeah.
So mom will see Grayson just on Wednesdays for a couple of hours.
Correct. And any other time she wants to message me, I'm open. I'm always open, Your Honor.
Okay, so if the court adopts this recommendation, the father shall have the next 7 overnights. That will be the next 2 weekends, correct?
We do it every other weekend.
Okay.
So let me look at my calendar here. I would get her, which would be Friday the 1st and 2nd. That would be Mom's week. And then November 15th and 16th would be Mom's week. And then the 29th and 30th is Mom's week. Those are the next 3 weekends.
Okay. And Mr. Schieb, do you think you need to do all 3 weekends?
That's all the time I was denied, Your Honor. And quite frankly,
understand.
that was again the time I was supposed to spend on a vacation with my child. So now our time we're going to be spending is very limited because she's in school. But yes, I want all my makeup time back. It's my time with my child to enjoy.
Okay. So if you give makeup parenting time November 1st and 2nd, 15th and 16th, 28th and 30th, that's 6 days.
Oh, yeah. I'm sorry. I forgot to look one more. 29th, 30th. And then December the 13th would be the next.
Well, the court's going to, let's just keep things easy. The court's going to give dad 6 overnights, the next 6 overnights. So that will be November 1st and 2nd, 15th and 16th, 28th and 30th. And Mr. Pratt, if you can just change the recommendation, the court's just going to grant 6 days of makeup parenting time rather than 7.
Yes, sir.
All right. Mr. Ann Harper, do you have any questions?
Since it's overnights, would I be able to get Graceland Sunday or no?
Well, this is dad's makeup parenting time. So unless the two of you can agree, the answer would be no. The dad would have those weekends. The 3 weekends in November that you're entitled to would be dad's. November 1st and 2nd, 15th, 16th, 20th, and 30th. Obviously, if there's something that you want to do with Grayson, communicate with Mr. Schieb on app close. And I would hope that Mr. Schieb would want to try to do what's best in Grayson's best interests. And then hopefully and I would encourage that, Mr. Schieb, and maybe for mom to have Grayson a couple hours on those Sundays. I'd rather have to count hours. So, court will adopt Mr. Brad's recommendation and modify in terms of fathers entitled to the six days of makeup parenting time, which would be mom's next 6 overnights. And that would be essentially those weekends. And again, Mr. Schieb, try to work out so that Grayson can spend some time with her mom, maybe during the day on a Sunday.
Yeah.
Okay. All right. With that will conclude this matter. You can both zoom out.
Thank you.
Thank you.
Thank
Your Honor,
You're
that
welcome.
updated recommendation is in your queue.
Thank you, Mr. Brad.
Thank you.
No, I guess Petrangelo called, like, what's going on? Why aren't we in a breakout? Well, I can, but judge doesn't like me to because we're on record with another party. And then all these people are popping into our screen. That's disruptive.
Baron versus Baron-Chamberlain.
For the record, this matter is before the court for the purpose of reviewing defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Christina Hills representing the plaintiff mother, Christina Barron. Ms. Barron is present. In addition, Attorney Jeremy Burks is present representing defendant father, Derek Chamberlain, and both parties are present. Good morning, everyone.
Morning, Your Honor.
The parties have conferred this morning with the front of the court. The court received the fine recommendation that it's noted that family counseling shall start between father and minor child. The minor child's therapist shall recommend a counselor for family counseling. Family counseling shelter services shall also make a recommendation regarding a family counselor. The parties shall agree to a family counselor after receiving those recommendations. Family counseling, once again, shall start as soon as possible. Father shall video chat contact with the minor child every Thursday at 4 p.m. through app close. And further, that the father shall continue to have supervised parenting time with the minor child through family counseling shelter services. Mother shall add all of the minor child's extracurricular activities to the shared calendar on app close, and finally, the party shall appear back before its court to review parenting time, December 17th, 2024, 1:15 p.m. Once again via Zoom. That's the recommendation. Mr. Burks, is this recommendation good with your client this morning?
It is, Your Honor, but I think we forgot one thing in there, and that's that the plaintiff will sign a release for my client to get the information from the child's therapist.
That is correct, Your Honor. I don't know that that needs to be in the order. I've already given instructions via dictation to my paralegal to get that done.
Perfect.
We can add that to the order. Mr. Walker, you can maybe just add a sentence that the plaintiff shall execute a release and provide that release to Mr. Burks. Is that correct? This is release relative to the child's counselor?
Yes, since my client has sole legal custody at this time, she's going to sign a release so that he can have some communication with the therapist.
Okay, so the child's therapist, not the counselor, but the child's therapist. Okay. Do we need to put the therapist's name in this order? Does everyone know who the therapist is?
Christina, what's the therapist's name?
Yep, her name is Rachel Anderson.
Rachel Anderson?
Mhm.
And she's
That's the recommendation that the mother shall facilitate securing a release from the child's therapist, Rachel Anderson, to and for the benefit of the defendant filed, and that will be provided to Mr. Burks. All right, and with that addition, Mr. Burks, the recommendation is agreeable?
It is, Your Honor.
Yes, Your Honor.
Parties have conferred this morning with Mr. Walker at length. Does either counsel wish to voir dire your respective clients regarding this recommendation?
I do not, Your Honor.
I do not.
All right. All right, the court will adopt the recommendation with that additional provision. Now concludes matter. Thank you, Mr. Burks and Ms. Hills and Mr. Walker. All right, everyone can zoom out. Have a good rest of the morning.
Thank you, Your Honor.
Thank you, Your Honor.
Welcome. For the record, this matter is before the court. The defendant files objection to a referee recommendation, which denied his motion to modify custody and parenting time. This hearing is being conducted via Zoom. Present is Johnny Morton present on audio?
Yes, sir, Your Honor.
Right. Good morning, Mr. Morton. Also present on the polycom this morning is Attorney James Petrangelo, as well as the plaintiff mother, his client, Tacket. Good morning, everyone.
Morning, Your Honor. Good morning again, sir.
Parties met with Ms. Patrick this morning. Court should soon receive a recommendation from Ms. Patrick.
Should be in your de novo queue, Your Honor.
Oh, I'm sorry.
That's okay.
Gotcha. All right, I'm looking in the wrong queue. I'm sorry. Court has received following the novel recommendation. Recommendation is that the referee recommend order be adopted. Mr. Morton, do you understand the recommendation this morning?
Yes, sir, I do, Your Honor.
The recommendation is that referee recommend order be adopted, which denies your motion to modify custody and parenting time. You've discussed the matter with Mr. Petrangelo, Ms. Tacket, and Ms. Patrick this morning. Do you have any objections to the court adopting this recommendation once you've received additional information?
No, sir, Your Honor.
All right. Obviously, there needs to be better communication, Ms. Tacket. When there's an injury to a child, the two of you are joint legal, so you need to timely and promptly inform dad of any issues involving your minor child. Mr. Petrangelo, does your client understand that?
Yes, Your Honor. Well, we've discussed that, better strategies for the future.
Right, so you're asking the court also to adopt this recommendation, Mr. Petrangelo?
Yes, Your Honor.
Yes. All right, to Mr. Morton, do you have any questions for the court?
No, sir, Your Honor.
Right. Court will adopt Ms. Patrick's recommendation. Thank you, Ms. Patrick. You'll both mail a copy of this.
Thank you.
Please keep open those lines of communication, please.
Yes, sir, Your Honor.
Okay, now concludes here, and you can both zoom out. Thank you, Mr. Petrangelo. Thank you for your patience this morning.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
Matthew Bradley versus Rebecca Bradley Dooley.
For the record, this matter is before the court on the plaintiff's motion to modify spousal support. This hearing is being conducted via Zoom. You are Matthew Bradley, is that correct?
That's correct.
Right. Good morning. You are Rebecca Bradley Dooley?
Correct.
Okay. Both parties are present. Parties have met with Ms. Brower this morning. Ms. Brower is recommending that So it's before the court on parenting time as well as spousal support and child support. Is that correct, Ms. Brower?
Your Honor, Mr. Bradley filed 3 motions at the same time, a parenting time, a child support, and a spousal support motion. The parenting time and child support were sent to front of the court to schedule with the referees. I did address all of the motions this morning, and my recommendation is to vacate both referee hearings.
Okay, all right, thank you for the explanation. The other ones were not noticed for hearing before this court, just the one was about spousal support. So wait a minute, Mr. Bradley filed 3 motions to modify spousal support, child support, and parenting time. The parties have conferred with Ms. Brower this morning. Ms. Brower is recommending that the following, is that parenting time shall remain as ordered in the judgment of divorce signed 6 months ago, named on April 5, 2024. There needs to be a significant change of circumstances, Mr. Brower, to change parenting time. The Michigan law requires that indicate that children need consistency, continuity, and courses cannot randomly, willy-nilly change parenting time unless there's a significant reason for the change circumstances. So the recommendation is that the parenting time continue as previously ordered in the judgment of divorce. Further, that so that your motion regarding modification of parenting time be denied. Further, that your motion regarding child support be denied, and your motion to reduce spousal support alimony be denied. And the hearings before the referee Hamrick on November 7th and referee McKee on November 18th be vacated. So things will continue as in that judgment of divorce. And if the court recalls the reason for your motions, Mr. Bradley, is that Miss Dooley has now secured employment. And you're arguing that things should be changed and reduced because of that. Mr. Bradley, do you have any objection? You talked with Ms. Brower. She's explained all these things for you. Do you have any objection to the court adopting her recommendation this morning?
No, Your Honor. We discussed it in the breakout room, and we found that it was not significant enough to make any changes.
Okay. All right. So you have no objection then to the court adopting this recommendation, correct?
Correct.
All right. Thank you, Ms. Brower, for explaining all that. Of course, the court notes the response board, the amount is modifiable over the next 6 years, but there's got to be a more significant of a change to modify that. And Ms. Dooley, obviously, you're asking the court to adopt this recommendation, correct?
Correct.
All right. All right. So you both should know on your calendars that the hearings before referee Hamrick on November 7th, the hearing before referee McKee, if you receive that November 18th, both those are canceled and vacated. No need for those. This court's addressing all 3 of those matters today.
Okay.
Okay. There being no further questions, the court will adopt the recommendation. Thank you, Ms. Brower, for your fine assistance in explaining to the parties these issues. The court will adopt the recommendation. Now we'll conclude this matter. You both emailed a copy of this order. All right. You can both zoom out. Have a good rest of the morning.
You too.
Okay.
Calling the matter of Nicole Lips versus Derek Lips.
For the record, this matters before the court on the plaintiff's motion for exclusive use of the marital home and supervised parenting time. This hearing is being conducted via Zoom. President is Attorney Scott Longton, representing the plaintiff, Nicole Lips. Ms. Lips is present with Mr. Longton. In addition, Attorney Brent Lampkin is present, representing defendant Derek Lips, and Mr. Lips is also present. Good afternoon, everyone.
Good afternoon, Your Honor.
The parties have conferred with Ms. Brower for the front of the court this afternoon, has provided the court with the following recommendation: that the children and father shall participate in therapeutic counseling. The parties shall bring a list of potential therapists to mediation, which is scheduled for November 7th, 3:30 or 1:30 with Mr. Pratt. Mother shall participate as the therapist may recommend. Plaintiff wife shall have exclusive use of the marital home commencing at 5 p.m. today until Sunday, November 3rd at 5 p.m. and defendant shall have exclusive use of the marital home effective November 3rd at 5:30 p.m. until mediation, which is November 7th at 1:30. The parties maintaining exclusive use of the home shall ensure that all animals at the home are being fed and cared for. Communication between the parties shall be only regarding the children pending mediation. That's a recommendation on a temporary basis. Mr. Longton, is this recommendation agree with your client this afternoon?
Yes, just one point of clarification as I was reading this again, Your Honor, is that when my client is out of the marital residence, the children will be with her. They're not being left in the marital residence. So the children will move with my client out of the marital residence, leading into mediation until we can work on a resolution of this matter.
Okay, if that's the the recommendation that should be specified, Ms. Brower, in the recommendation. With that clarification, Mr. Lampkin, is this recommendation agreeable with your client?
Yes, yes.
Okay. All right. Both parties did participate in the discussions with Ms. Brower. Does either counsel wish to provide their respective clients regarding this temporary arrangement?
Just briefly, Your Honor. Ms. Lips, you've heard the discussions that went on with Ms. Brower and Mr. Lampkin leading into just now, correct?
Yes.
And you are satisfied with this agreement on a temporary basis leading into mediation?
Yes.
Nothing further, Your Honor.
All right. Mr. Lampkin, do you have any questions of Ms. Lips or Mr. Lips?
Briefly with Mr. Lips. Mr. Lips, you were a party to the hearing before the referee, is that correct?
Yes.
And you heard all of the statements made by myself, Mr. Longton, and your wife?
Yes.
And also Ms. Brower?
Yes.
And you heard the recommendation that she came up with?
Yes.
And you participated in that?
Yes.
And do you agree to abide by that between now and mediation?
Yes.
Okay, nothing further.
The court will adopt the recommendation. We'll include in there the provision that the children shall move with mom. November 7th, mediation is 1:30, is that correct?
Yes,
Mr.
Your Honor.
Pratt?
Yes.
Okay. Unfortunately, the court will not be available after 2:30 on November 7th. So what I'm suggesting is if the parties want to place something on the record, they can always appear before the court the following morning, which is the November 8th.
Your Honor, in the event, do we have a scheduled settlement conference after that also?
We do.
Okay. So, Your Honor and Mr. Lampkin, would everybody be available at 8:30 on Friday in the event we have a resolution?
Yes.
Okay, so if ever, yes, so ignore the prior notice. If ever can just zoom in on the Friday, November 8th at 8:30. The court can either entertain an agreement. Hopefully, we have two capable family law practitioners. If not, the court can schedule an evidentiary hearing if necessary or address any other issues.
Thank you, Your Honor.
Thank you.
Welcome. Thank you, Ms. Brower. If you just add language that the children shall be with mother during the period of time that mother leaves the marital home.
Yes, Your Honor. Would you like me to put the pretrial for Friday morning on the
That'd be
recommendation as
wonderful.
well?
That'll be wonderful. The parties shall appear for mediation on November 7th, 1:30, and appear before the court for a continued pretrial November 8th at 8:30 via Zoom.
All right.
All right, if there's nothing further, that'll conclude the matter. Thank you, Ms. Brower, Mr. Lampkin, Mr. Longton, for helping facilitate resolution. Mr. and Ms. Lips, the two of you, the reality is, you got two children that are soon be entering their teenage years. Effective communication is key. If you want them to do well in life, and there's enough challenges in life, make it good for each other and the children. Maybe you need to talk about even listing home for sale. If neither one of you can afford it to buy out those interests, then that's what you look at is selling, liquidating that marital home. That's the reality. So in any event, that'll conclude this hearing. Everyone can zoom out and have a good rest of the afternoon.
Thank you, Your Honor. Have a good day.
Brent Lampkin is present, representing the defendant. Derek Lips, and Mr. Lips is also present. I'm sorry. Good morning, everyone.
Good morning. Good morning.
Parties did engage in mediation with Mr. Pratt on Thursday, yesterday afternoon. Was there any progress made, Mr. Longton, Mr. Lampkin?
Yes, Your Honor, substantial progress. There is one issue that I think me and Mr. Lampkin were going to maybe get some direction from the court on. There is another issue that I think the parties were going to discuss to potentially finalize or modify that we needed to talk to them about real quick. So the issue that we were looking for direction from Your Honor is the extracurricular expenses of the children. Traditionally, how Your Honor views paying for those expenses. In this case, we have.
Hey, Scott, I'm sorry to interrupt, but I think we have an agreement on that. I can let you know what that is.
Oh, I apologize, Your Honor. I was unaware of that.
That's fine. Do you want to talk in a breakout room for a few minutes this morning?
That'd be great, Your Honor.
Yeah.
Okay.
Full Lips versus Derek Lips.
Court's back on the record in this matter, both parties being present, as well as Attorney Scott Longton and Brent Lampkin. Parties have conferred further this morning in a breakout room. Mr. Longton, Mr. Lampkin, where do things stand?
Your Honor, we have resolved all issues with finite detail. So we have some final structure for these parties to follow going forward that we'd like to put on the record.
Wonderful. And who'd like to do so?
I will, Your Honor.
Please.
Thank you, Your Honor.
Welcome.
Your Honor, there is a marital residence. The parties are going to be staying at that marital residence together. Mr. Lips will vacate that marital residence on or before December 15th, 2024. The status quo will continue. However, it will be a little bit different than they have historically been doing it. They are going to have their separate bank accounts. The status quo of the household marital expenses are going to be paid on a pro rata amount based on their incomes. That pro rata amount is 67% to Mr. Lips, 33% to Miss Lips. That amount is based upon the front of the court calculations of their incomes. The current bank account, any funds in that current bank account will be equally divided between the parties. As it relates to parenting time, there's a number of factors. Mr. Lips is going to submit to SoberLink for a period of 4 months. Miss Lips is going to be responsible for the fees and expenses of the SoberLink. If at any time Mr. Lips has a positive test for alcohol, positive means a actual positive for alcohol, or a missed test, which is not then corrected because SoberLink gives you a time frame to correct a missed test. If he has a missed test, which is not corrected, or a positive test, then Mr. Lips becomes responsible for all fees going forward for the remaining 4 months and any fees that Miss Lips incurred prior to that. So he would be responsible for the entire thing. At the end of the 4 months of SoberLink, there will be a review of parenting time and the SoberLink itself. The parenting time in this case is going to be to Mr. Lips alternate weekends, Saturday at noon to Sunday at noon, and then every Wednesday during the week for dinner from 6 to 8. There is going to be joint legal custody between the parties. I apologize, Brent. The holidays were per the Monroe County holiday schedule. Okay, the holidays will be per the Monroe County holiday schedule. And going back to the parenting time and the SoberLink testing is only during Mr. Lips's parenting time. It is not 7 days a week for 4 months. It is just during his parenting time. So anytime he has parenting time, whether it is holiday parenting time or it's his regular scheduled parenting time, that's when he's doing his testing. The marital home is awarded to Miss Lips, free and clear, with the exception of a $5,000 payment of equity to Mr. Lips. The equity will be paid upon refinancing. Refinancing will occur on or before 7 months of entry of the judgment of divorce. There is no spousal support to either party. Spousal support is forever barred. Child support in this case, Mr. Lips will be paying to Miss Lips $1,540 per month for 2 kids. That's $1,489 for base support, $51 for ordinary medical. There is no offset for premiums, insurance premiums for either party, and there is no daycare for either party. That is based upon 75 overnights with the 2 children. When there is 1 child, child support would drop down to $995. That is a base support of $969 and ordinary medical of $26. The extraordinary medical would be 67% to Mr. Lips, 33% to Miss Lips. That would commence January 1st, 2025. And just to clarify, the status quo will continue until that January 1st, 2025 date as well. The parties are going to seek a therapist per the previous order of the court for the children and Mr. Lips and the family. If the parties are unable to to determine a therapist in the next 7 days. Then myself and Mr. Lampkin will compare a list and we will choose one for them. They are each responsible for any debt in their individual names. There are a number of vehicles. Mr. Lips has a Camaro, a boat, and a Chevy Bolt with a B. Mr. Lips is awarded all three of those vehicles or recreational vehicles. There is a Chevy Silverado, which has a current lease, which does not expire for approximately, I believe, 9 months, maybe longer. But the parties are going to pay for that vehicle, that Chevy Silverado, jointly, each being responsible for half of the payment of the vehicle payment and the insurance. They will each have access to that vehicle. There is an extremely limited number of miles left on the lease, given the length of the lease is our understanding. They're going to be working on early turning that vehicle in or selling it to minimize their expenses on that vehicle. They're going to be working jointly on that to benefit each of them. There is the Camaro, as of right now, is in pieces. It's in the pole barn at the marital residence. Mr. Lips will have the Camaro out of the pole barn on or before January 15th, 2025. The boat is also in the pole barn. The boat will be able to remain in the pole barn until March 31st, 2025. That's so that he does not have to incur the cost of shrink wrapping and finding a place for storage right away. There is, I apologize, I'm jumping around a little bit. The Silverado, in the event that they turn it in and there is a deficiency, they will each be responsible for half of the deficiency of the Silverado or any outstanding expenses for that Silverado. As it relates to extracurricular activities, the children right now are in equestrian, horseback riding, and hockey. Hockey is going to be split 50-50 between the parties. Equestrian is going to be split 50-50 between the parties, with the exception that the children are typically in 3 shows, horse shows per year. The average cost of the horse shows is $100 per child. If at any reason the horse show would be significantly more than $100 per child, then that cost would need to be discussed and agreed upon before incurring substantially more for those individual shows for the children. But all other expenses of the equestrian will be split equally between the parties. I believe that I have covered all of the settlement agreement at this time.
Thank you, Mr. Longton. Mr. Lampkin, was that a correct statement of your client's agreement?
It is with, I have an addition. They're both being awarded their own retirement accounts.
Yes.
And I believe we covered everything. I'm trying to think if we left anything out. I think we got everything covered. Yeah.
I apologize. There are 2 different issues with the retirements. They're each awarded their retirement accounts, meaning their 401ks. Mr. Lips's retirement account is a retirement savings plan. However, Ms. Lips would be entitled to 50% of any pension that Mr. Lips has of the marital portion.
He doesn't have a pension though. He advised me he's not in the pension program.
Okay, we weren't sure. So if he is, then for some reason I had a client recently find out that he was and didn't know it. She'll be entitled to 50% of the marital portion. But as far as the 401ks, retirement saving plans, they are each awarded their own retirement accounts, Your Honor.
Right, but if it's discovered that Mr. Lips has a pension, then Ms. Lips is entitled to 50% of the marital portion. Is that correct?
I would think so, but is Mr. Lips there?
Yeah, GM doesn't give pensions anymore. That's why there's 401k match. The pensions went away, I believe, in 2008. So I do not have a pension anywhere.
Okay, we can secure that by virtue of testimony. Very well. Mr. and Mrs. Lips, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Yes.
Thank you. All right, Mr. Longton, you can begin with Ms. Lips. If you can proceed with the proofs, please, and confirm with her her understanding of this agreement, please.
Thank you, Your Honor. Ms. Lips, at the time you filed your complaint, did you live in the state of Michigan for 180 days immediately prior to filing?
Yes.
Did you live in Monroe County for 10 days immediately prior to filing?
Yes.
Were all the allegations in your complaint true?
Yes.
Are they still true today?
Yes.
If the court was not to grant your judgment of divorce, is there any chance of reconciliation with your husband?
No.
Besides the 2 children that are addressed in the settlement, are there any other children born or adopted to you and Mr. Lips during the course of the marriage?
No.
Okay. Are you currently pregnant?
No.
I have nothing further on the statutory proofs, Your Honor. Ms. Lips, you heard the settlement agreement as we placed it on the record with the clarifications that Mr. Lampkin and myself made at the very end, correct?
Yes.
And do you agree to be bound by that settlement agreement?
Yes.
You understand that you had the right to go to trial?
Yes.
That had you gone to trial, you could have been awarded something similar or different, which could have been better or worse for you.
Yes.
You understand that you had the right to modifiable spousal support.
Yes.
That this agreement bars spousal support, meaning it is set to 0, and you can never come back and ask this court for spousal support in the future, and neither can Mr. Lips. You understand that, correct?
Yes.
And you're asking the court to adopt that as your binding settlement agreement.
Yes.
As it relates to the children, do you believe that the custody and parenting time provisions are in the best interest of your minor children?
Yes.
Do you believe that you can foster a loving relationship and promote that relationship between the children and Mr. Lips as appropriate with the help and the terms that we have set forward in helping the family moving forward?
Yes.
And knowing that you are asking the court to adopt the custody parenting time provisions with all of the requirements as your settlement at this time, correct?
Yes.
Okay. Are you satisfied with my services?
Yes.
Nothing further, Your Honor.
Thank you, Mr. Longton. Mr. Lampkin, do you have any questions, first of all, for Ms. Lips?
No, not for Ms. Lips.
All right, questions for Mr. Lips, please.
Yes, Mr. Lips, you had an opportunity to hear the settlement that was recited on the record.
Yes.
Are you in agreement with all of its terms?
Yes.
You understand with regard to property and debts, it's a full, final, and binding settlement?
Yes.
And that means that they can't go back and change the terms of those?
Yes.
With regard to spousal support, you understand you will not be paying any spousal support to Ms. Lips?
Yes, I understand.
And you'll not receive any spousal support from Ms. Lips?
Yes.
And you understand you're waiving that right?
Correct, yes.
You also understand that with regard to the custody and parenting time agreement, you believe that's in the best interest of your children?
Yes.
You understand you won't have a trial in this case?
Yes, I understand.
And you're waiving your right to trial?
Yes.
Okay. I don't have anything further for my client.
Thank you, Mr. Lampkin. Mr. Longton, do you have any questions for Mr. Lips?
Just one. Mr. Lips, you previously stated that you do not have a pension. It's your understanding that GM does not have a pension. Is that accurate?
That's correct.
Thank you. Nothing further, Your Honor.
Right, Mr. Longton, you'll prepare the judgment, is that correct?
Yes, Your Honor.
To the court in 2024, is that correct?
Yes.
All right. Very well. The court would like to thank and acknowledge attorneys Longton and Lampkin for helping facilitate amicable resolution. And the court would applaud you, Mr. and Ms. Lips, for reaching your own agreement. You were both served by 2 very capable family law practitioners, and the court can assure you the best resolution is the one in which you participate and ultimately agree upon. Far better off than having the court decide these matters. And it's wonderful you can co-parent your 2 children. Obviously, if the equestrian activities are important, hopefully you'll be able to agree upon sharing that cost in the future, even if it increases significantly, if it's important to the children. So always please keep in mind their best interests. Little things are important. like Mr. Lips, when it's Mother's Day, make sure your daughters get cards from mom, and mom likewise make sure they get cards for dad for Father's Day. Those little things mean a lot to your children. So please communicate in the future for their best interests. Based upon the testimony that's been presented this morning, as well as complaint filed in this case, the court finds that jurisdiction has been established and that there has been a breakdown of the marriage relationship to the extent that the obviously matrimony has been destroyed. Unfortunately, there appears to be no reasonable chance of reconciliation. Accordingly, upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from the bonds of matrimony. Good luck to both of you. If your children will thrive if you're both on the same page for their benefit, notwithstanding the divorce. So please keep that in mind and work together for their best interests. They will sense when there's animosity and tension. So obviously you want to minimize that for your children. So good luck to both of you. Thank you again, Mr. Longton and Mr. Lampkin, for your fine assistance.
Thank you, Your Honor.
Thank you. Thank you.
That would conclude this matter. You can everyone can zoom out. Have a good rest of the day.
Have a good day, Your Honor.
Thank you. Yeah, I've got to. Okay. We're bringing in 5 minutes. Thank you, Ms. Brower.
You're welcome. That mediation, or I'm sorry, the pretrial was at 8:30 a.m. on Friday, the 8th, correct?
Correct.
Okay.
I forget what kind of tree that is. It smells
Oh
terrible.
my God, it smells terrible.
You know
That's
the
all I
one
can
in front of the
smell right now.
library?
Yeah.
It is it.
Ginkgo. Ginkgo.
Ginkgo.
Is that what it is? Okay,
But-
I must have stepped in one because that's all I can smell.
Yeah, they're nasty. But interesting, my neighbor has a ginkgo tree inside yard. It's a male ginkgo tree. No, it doesn't drop the little balls. So I don't know, is this a male or female? I'm just telling you, it's got the same exact leaf. It's a distinct pattern of a leaf, and they're gold, but it does not have the berries.
Really?
Terrible. They're terrible.
God, they're terrible.
So stop in there and ask, is it male or female? What do you think? Well, I don't know. I don't know.
That's so crazy.
I assume there's a female because female produce.
We've got 2 of them in our house.
What is it called?
Miss Brower might know.
What is the question?
The garden, the ginkgo tree in front of the library. It's dropping its berries, and of course, they're like stink bombs. My neighbor has a ginkgo tree in the yard, but it does not drop berries. So do you think the one in front of the library, maybe Mr. Walker knows, is it a female ginkgo tree or male ginkgo tree?
I honestly have no idea.
Female ginkgo trees smell bad.
I haven't
Okay.
checked under under its leaves, so I don't know if it's male or female. Oh, that was a bad joke. I'm sorry.
I didn't realize there was such a thing. My neighbor has ginkgo tree, the same distinctive leaf, but it does not drop the berries. So I'm assuming the female tree would produce berries. So I'm assuming the one in front of the library.
Yeah, I don't know. I didn't know there was a male and female also. I thought most, I don't know. I thought most plants are not male or female. They're
Binary.
Binary? Yeah, they're usually both.
Peppers are.
Oh, he doesn't know how to address this.
They're non-binary. All right, so
I had a complete
I'm ready
questionnaire
on
from the
my
University
case.
of Michigan, and there was like 6 categories. Somebody's never heard of.
Yeah.
And there used to be just male or female. Now it's, binary. I don't know. There's like the other ones, can't remember what they are, but they're categories I never heard before. Didn't quite understand what they were.
Well, you should talk to my daughter. I think she told me there's somewhere around 96 or so different categories now.
Wow.
But I'm ready on my.
I'm glad we clarified that this afternoon. It's been, so stay away from the library.
Stay away from the library.
Judge, my new recommendation is in your queue.
Thank you.
Okay.
You're welcome.
Are we
Yep,
ready
yeah.
for the straws?
Yep. Yeah, if you can delete the other one, Aaron, appreciate it.
Right.
We don't
I'm gonna
want
go
it.
get them. I know
I
you
will
don't
have-
mind. I'm gonna go get them.
I'll have someone delete the other recommendation, Judge.
Aaron, did we put in there that the children will be with mom?
Yes, it's in the language. I put they shall remain with plaintiff pending mediation.
Oh, gotcha. Yep.
It's in the third line under notes.
Sign that one. Thank you.
You're welcome.
And hopefully Josh has an agreement. Nancy wanted this file. You want to give it to her, or should I give it to her?
Which one was that?
This file.
Which one?
That's.
I know he did. And
Okay.
if she needs it,
Okay.
yeah, if she needs it, but that's not for her until 11/7.
Yeah, but she has to do the notice.
Oh, gotcha.
I'm guessing. I can't do it. Are you-
Is it female?
It is female too.
I assume because, females are produce.
Calling the matter of Heather Straub versus Charles Straub.
For the record, this matter is before the court this afternoon for the purpose of reviewing defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Christine Hills, representing the plaintiff mother, Heather Straub. Ms. Straub is present. Defendant father Charles Straub is also present. Good afternoon, everyone.
Good afternoon, Your Honor.
The parties have conferred this afternoon with Mr. Walker from the front of the court. The recommendation from Mr. Walker should be forthcoming.
Yep, Your Honor, I'm trying to get the recommendation to your queue. It's taking a little bit longer than normal. Just 1 second.
Okay.
All right, you should have that now, Your Honor. I apologize.
No problem. Yep. All right. The recommendation from Mr. Walker from the court is as follows. Defendant father shall have supervised parenting time at family counseling shelter services. Parties shall pay for their own intakes. Father shall pay for all sessions. Further, father shall complete a psychological evaluation paid by insurance or by plaintiff if not covered by insurance. And a review hearing may be scheduled by Mr. Straub after the psychological evaluation has been completed. Obviously, this is a change from our last order of August 7th, where father had parenting time, alternating weekends supervised by paternal grandparents. Obviously, something has happened in the interim, Ms. Hills.
It has, Your Honor. Mr. Straub has had a falling out with his parents, which appears to be centered around his father attempting to get him to admit himself to St. Joseph Hospital in Ann Arbor or Ypsilanti for a psychological evaluation.
And so the parents cannot agree upon anyone else to supervise parenting time. Is that correct?
That's correct. There is no one else. Mr. Straub is living with his brother currently. His brother is unwilling to take on that responsibility, and there is no one else. And frankly, I believe that a professional setting is the best for this situation currently, anyway.
All right, so you're asking the court to adopt this recommendation, Ms. Hills?
Your Honor, I do have concerns about asking my client to pay for the psychological evaluation unless it's covered by insurance. It is not my understanding that Mr. Straub has insurance. So he indicates that he's living in Monroe County. He would be able to get an evaluation, or at least get some treatment started with Monroe County Community Mental Health at no cost to him as someone who's uninsured, or they would refer him to someone if he's able to get Medicaid who would accept his Medicaid insurance. He does indicate that he's working. As the court is aware, child support right now is set with parenting time at 50-50, 182 and a half overnights each. He is having no overnights of parenting time currently, so my client is having to pick up the slack of the 50% of the time that Mr. Straub would otherwise have the kids if it weren't for the issues that he's having. So I do not believe that it is fair or equitable to ask my client to pay for a psychological evaluation for Mr. Straub. We did have an additional request. Mr. Straub has taken to messaging my client in the middle of the night, primarily between the hours of 1 and 3 a.m. She has actually had to turn off notifications because it was so disruptive of her sleep in the middle of the night. So we are asking that Mr. Straub not message her at all between the hours of 9 p.m. and 6 a.m. And given that one night he messaged her 48 times, we're asking that he not message excessively either.
All right. Any objection, Mr. Straub, that you not communicate with Ms. Straub or text her between those hours of 9 p.m. and 6 a.m.?
I have absolutely no objections to that.
All right. So, Mr. Walker, if you can add that to the recommendation that the defendant shall not communicate with phone, text, or FaceTime Ms. Straub between the hours of 9 p.m. and 6 a.m. each week. All right. All right. Thank you, Ms. Hills. Mr. Straub, do you understand the recommendation?
Yes, I feel like I've fulfilled what you guys wanted from me before, and I definitely feel like there's no need. The only problem in my life is that I really miss my children and I want to get back to having a normal relationship with them. And I had no problem. The falling out with my father had to do with my father being an alcoholic and he's drinking. And it had absolutely, and I didn't feel like it was a safe environment for my children. And I don't stay there. I only stay there because of the the recommendation for you guys to have me watched, whatever it's called, for the child care. But I was a stay-at-home father with, and Ms. Straub trusted me for, the kid's whole life to stay home with them and watch them and take care of them. And other than our divorce, absolutely nothing has changed. And I feel I have a job. I took the anger management. I started going to church, which I haven't found one that up here that I went to in Tennessee, but I'm going to. But I feel like my mental health is great. I just would really like this divorce to finally end, and so I can.
Divorce is final. Mr. Straub, divorce is final.
Well, I mean the child custody where I haven't been able to see my children.
Okay. Well, obviously, if the court, first of all, Mr. Hills, did you receive documentation that Mr. Straub completed anger management counseling?
He did complete an online course, which he had been doing somewhat better when my client agreed that that would be acceptable. Since then, again, the middle of the night messages, the 48 on one night, and more messages, not to me recently, one since the last court hearing, but he's left a message for Tim Evans, threatening litigation against him and very angry. He has involved Miss Pastrana, accusing her of being part of the mafia. She's simply trying to get him his share of my client's 401k. Just very erratic and unstable behavior. He has this story about being in Tennessee with some very hard to believe things that supposedly happened to him down there, which appears to be some sort of a psychotic break that he's had. So we don't feel that the anger management that he did was sufficient to address his, what we believe, ongoing mental health issues.
Right, Mr. Straub, obviously, Ms. Hills, your client should know her future former father-in-law. Is he an alcoholic?
I mean, he drank. Do I know if he's an alcoholic? I wouldn't say. I mean, he works at GM and he's worked there for a long time. He's always seemed like a good guy to me.
Okay.
And the parties did both agree to use him as, along with Mr. Straub's mother, as a supervisor for parenting time. So Mr. Straub had no concerns when that was agreed to.
At the time, I was staying with my brother and I wasn't aware of their problems. And as a good father, when I did become aware of their problems, I even gave up the little bit of parenting time I had to make sure that they were okay. And that's what a good father and responsible father would do. And that's why I feel like with fulfilling everything the court wanted up to this point, proving that I'm a good father by making that hard decision, I feel like, and now that I'm back at my brother's house, now that I don't have to do the supervised visitation, the kids have a room, they have food, they have bedding, everything in our lives can go definitely back to normal, where I can continue to have the bond with my children that I had their whole lives.
Mr. Straub, you have exhibited conduct which is of concern to this court, especially as it may affect your children. The fact that, first of all, after the divorce finalized, you blew up and threatened Miss Hills, and then, of course, why someone would text someone 40 some times in a given night is clearly suspect and unreasonable and inappropriate. The fact that you would reach out to the appraiser after the fact, or to the attorney that's preparing the call for domestic relations order, of all of concern to this court, and the court believes that your parenting time, since your parents won't do it anymore, that things have happened, your parenting time shall be supervised at Family Counseling Shelter Services. So you need to call them today and schedule that intake. Do you have their phone number? We want you to have contact with the children. Mr. Walker, do you have their phone number, Ms. Hills? Right, you have a piece of paper and a pen, Mr. Straub?
I refuse to be further tortured and ridiculed by this court. And if you order me to do that, I'm just not gonna see them. Because I
Okay,
don't feel like you have proved any proof of anything Ms. Hills has been saying. It's all hearsay and it's lies. And threats of litigation are not physical threats, which she admits that those were not physical threats. And so I'm not really sure why the recommendation of the court is even what it is. And I definitely feel like I'm being picked on and discriminated against.
Mr. Straub, Mr.
If I
Straub,
take that recommendation,
Mr. Straub,
what would stop
who would
me from
text someone
continuing?
40 times in a night? Do you deny that you texted
She
her 40
texted me
times in
back.
one night?
She texted me back asking me for food money and saying she
No.
didn't have food for the children.
No,
Have you seen the text? I have the
I
proof
have
of
them.
it.
I have
And
them.
what was I? Was I threatening you?
No, but 48 times between the
Absolutely.
hours of 12:30.
So they were
and
not
2 o'clock.
threatening. You filed divorce 5 times, Heather. How did I know you're being serious this time?
All right.
I
All right,
don't.
the court, I'm gonna set another, I will set a review date, Mr. Straub, because I want to keep this on my docket. I want to reestablish relationship between your
I know
your
you want to keep
children.
me on here and keep me
So,
strung along and not just let me move on
Father's
with my
parenting
life.
time shall be supervised, FEMCOM shall service,
I'm
call
not
them as soon
doing
as
it.
possible, schedule those
I will
intakes,
not
and
do
set
it.
those sessions.
I refuse to do
Also,
it. I refuse this.
all right, the court
I
will
will
also
not
the
do
father
it.
complete psychological evaluation,
I will not do
period. Will not order that plaintiff covered right now. We'll reserve that issue, Mr. Walker.
Then I will be moving out of this state because I am being discriminated against by this court.
You date,
Absolutely,
Mr. Straub?
100%. You have proved no proof that I'm a danger to anyone, but you guys have proven that you are willing to step all over my rights and
Straub,
discriminate against
do
me
you
for
want to
freedom of
come, do you want a review date in this court's docket?
No, I don't.
All right, okay.
Then I will not see my children ever again.
It's unfortunate you're taking that position. That you contact community mental health and meet with someone.
I will not see my children ever again if you continue to step on over my rights with no proof that I have a danger to anyone.
Right, so
Supply
the
the
court
proof.
will adopt the recommendation. Mr. Waffey had 2 things. There should be no phone calls or text messages between the hours of 9 p.m. and 6 p.m. from the defendant father to plaintiff mother, and father shall secure a psychological evaluation, period. He should be able to get that done by community mental health. I'm sure they can help him with the
Well, have a good day because I'm moving to
associated with
Virginia.
that.
Goodbye.
And we will not set a review date. Mr. Straub does not want.
I'm not going to do the review date because you are doing this without any proof that I am a danger to anyone. I have done nothing but prove that I am a great father. I am a great person. But you will have proven that this court is willing to violate my freedom of speech and my rights based on lies from whomever to try and punish me for absolutely nothing, which this is actually torture. You're not letting me see my children with no proof that I'm a danger to anyone. And so the only way I'm going to get my rights is clearly to move out of this state, which I am willing and prepared to do. And I'm telling you right now, that is what I'm going to do. So by you making this recommendation, you are now turning me into a deadbeat father that you have desperately tried so hard to turn me into, which that I have proof of.
Well, the court does not agree with you, Mr.
we feel that
Straub. Maybe talk to an attorney. The court wants nothing more than to
An attorney, so what would the attorney
That's
change?
why the court
Would the
want to
attorney
place it on its
change?
docket, and you did
What
not
would he
want
tell
to put
you?
it on the court's docket. So that will conclude this
What?
hearing.
Yes, have a good day.
Thank you, Honor. You're all set, Heather.
Okay.